If conduct not intended as an assertion, then likely not hearsay. Inscription that is personal, then is hearsay, such as the Witter example that we went over in class. Inscription, logo, or verbal objects, not hearsay, if by a corporation in regular course of business. If marking time, likely not hearsay. If verbal marker, likely not hearsay. If it's an implied assertion in federal courts, then it's not hearsay. Federal jurisdiction. If it's implied assertions in Texas jurisdiction as verbal assertions, such as letters, then Texas follows the Wright v. Tatum approach that only if implied from verbal assertions, but not from nonverbal conduct. So that means it's hearsay if we have implied assertions such as writing a letter to somebody to discuss a contract impliedly asserts that the writer of that letter thinks that the person receiving the letter is competent. In the federal jurisdiction, that's not hearsay, but in Texas, it is hearsay because it is implied from verbal assertions. But Texas and the federal rules hold that nonverbal conduct is not hearsay. Nonverbal assertion, not hearsay. If it's see-do rule, not hearsay, because there's no hearer. Circumstantial evidence, such as for state of mind, memory, or belief, is likely not hearsay. Effect on listeners, such as trying to include acting reasonably in good faith, is not hearsay. Likely not hearsay. Again, effect on listener is likely not hearsay. Conditional relevance, likely hearsay, but sometimes it's not. An example, evidence to be supportive in finding of 104B, evidence that the jury could decide an issue such as authentication. Here's the definition of conditional relevance. Rule 104B creates an exception for conditional relevance. Conditional relevance is a complex concept that allows the judge to send a question to the jury contingent on the jurors finding certain facts. The judge must send such evidence to the jury if reasonable juror could find the fact in question. If it's independent legal significance, then likely not hearsay. Four main groups of hearsay exceptions. 801D are hearsay exclusions, not hearsay. So, Rule 801D, prior statement, and then prior, so here they are. Prior inconsistent statements, prior consistent statements, prior statements of identification. Next category, 801D2, admissions by a party opponent. Next, 803, hearsay exception, availability of declarant in material. And finally, declarant unavailable, or 804B, hearsay exceptions, declarant unavailable. And finally, 807, residual exception catch-all. Prior inconsistent statements, 801D1A, no declarant testifying. Prior inconsistent statements, 801D1A, the witness must now be cross-examinable concerning the prior statement. 2, statement must be inconsistent with present testimony. And 3, it must have been made under oath in a prior proceeding or deposition, such as a grand jury. Prior consistent statements, Rule 801D1B. Prior consistent statements. 1, witness must be cross-examinable at trial concerning the prior statements. 2, statement must be consistent with his present testimony. 3, must be offered to rebut a charge of recent fabrication or improper influence or motive. Comes only after impeaching attack. 4, prior statements of identification. 801D1C. 801D1C, prior statements of identification. Declarant testifies at trial and is subject to cross-examination concerning the subject matter of his statement, and, conjunctively, the statement is one of identification of a person made after perceiving him. Admissions by party opponent. 801D2. Admissions by party opponent. A party's own statement in either an individual or party's representative capacity. Statement the party has manifested an adoption or belief in its truth. Statement by a person authorized by party to make a statement concerning the subject, or a statement by an agent or of a party concerning matter within the scope of employment, or statement by a co-conspirator party during the conspiracy. Statement against interest versus statement of party opponents. Statement against interest is unavailable, has three elements: unavailable, against interest, any witness or party. The next statement of party opponent has three elements: statements by party opponent, and three can be self-serving or against interest. Individual admissions, 801D2A. Party's own statement manifested belief in its truth. Party's agent limiting instruction by jury. 801-2B, adoptive admissions. It can be a statement spoken or written by another. If X manifests his adoption or belief in its truth, the X becomes the declarant and the statement becomes his own. Admissibility of silence. Admissibility of silence. The listener has knowledge of the statement, has to be the kind of statement you would deny if it wasn't true. If D said he didn't do it, or didn't hear the statement, then it would be contradictory relevance. Actually, it must be actually heard. Admissions by speaking agents. 801D2D. 801D2D. Admission by employees and agents. A statement by the party's agent or servant concerning a matter within the scope of employment, the scope of the agency or employment, made during the existence of the relationship. The example here is the Wild Canid case. If you are acting within scope of employment, then the acting statement can be brought in. Co-conspirator statements, 801D2E. Co-conspirator statements, 801D2E. Statement to be made by co-conspirator, co-venturer, during course of a conspiracy, pendency, and conjunctively, in furtherance thereof the conspiracy, furtherance. So we have co-venturer, pendency, and furtherance. And the judge decides these facts under 104A through preponderance of the evidence. 803, hearsay exceptions, availability of declarant immaterial. Unrestricted exceptions, present sense impressions, excited utterances, state of mind, statements to physicians, past recollection recorded, and business records, and public records. Applies regardless of whether declarant is available as a witness. Present sense impressions, 803.1. Present sense impressions. Statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. Virtually no time has passed. Excited utterances. Excited utterances, 803.2. A statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. State of mind, 803.3. The then existing mental, emotional, or physical condition, not including a statement of memory or belief unless it relates to the execution of a will. Existing physical condition, then existing mental condition, or emotional condition, or subsequent conduct. The rule for mutual life insurance versus Hillman, 1892. Use of statement of intention to do something in the future as proof they did it. Rule. State of mind of proof of conduct. But 803.3 does not allow us to use the state of mind of proof of a third party. So you can say what you were planning on doing, but you can't use those statements of what you said to prove what somebody else was doing. 8033 exception, facts about a declarant's last will and testament. 8033 don't need special language for a testator's existing state of mind. In will cases, we have clauses that allow backward looking of statements when dealing with execution, revocation, or terms of declarant's will. Statements to physicians, 8034. Statements for purpose of medical diagnosis or treatment. Statements are admissible insofar as used for diagnosis or treatment. Exceptions. Statement attributing fault or identity usually are not admissible, such as a patient saying he got hit by a car. That's okay. However, the patient saying that this person over here did it is not okay. Past recollection recorded, 8035. Declarant must be unavailable to testify. Past recollection recorded. We have elements here, 5 elements. First, showing the writing to the witness fails to jog his memory. 2, personal knowledge at former time. 3, the writing was made by witness, adopted by the source. 4, writing occurred while event was still fresh in memory. 5, witness was able to vouch for the accuracy of the writing at the time it was written. Not admitted as exhibit, but may be read to jury. Business records exception, 8036, has 4 elements: regular business regularly kept, personal knowledge of source, contemporaneity, foundation testimony, such as custodian of the records or other qualified witness. Hearsay within hearsay, 805. Hearsay included within hearsay is not excluded under the combined statements, conforms with an exception to the hearsay rule provided in these rules. If you have hearsay within hearsay, it will be admissible as long as each chain is met with one of the hearsay exceptions. Public records, 8038, public records and reports. Activities of the office or agency, no restrictions against criminal in a trial. Matters observed pursuant to legal activities and duties. Excuse me. Exclude matters observed by police officers in criminal cases. And 3, factual findings relating to investigation. Factual findings include opinions.